evening, friends. And being on a weekend, to cherish the knowledge sharing from Justice A. Hariprasad, always a thing to be cherished. And yesterday, like we did a webinar on art of oral advocacy in the appellate work. Today, we take the practical aspects, that is what we call litigation skill sets or litigation series. Today, we discuss on the criminal appeals, general principles for advocacy. Because as a lawyer, you would always be interested, and for that matter, even the public prosecutors, as to what could be the skill sets which one has to develop, how he has to cull out the facts, the law, the evidence, how they have to be marshalling of all these aspects. These all aspects we were discussing with Justice A. Hariprasad, a former judge from Kerala High Court and a director of Kerala Judicial Academy. He was apprising that he was taking some sessions in the Kerala Judicial Academy on this aspect. We made a request, why not take these issues to pan-India rather than restricting it to the academy itself. And when the students of law, lawyers, and all professionals can gain. And as usual, he was kind enough to accede to our request. Without taking much time, I will request Sir to take things forward. Over to you, sir.
Okay, thank you, my dear friend Mr. Vikas and Mr. Pradeep Kumar, all my good friends. Good evening to all. Now, actually, as Mr. Vikas pointed out, I was actually addressing the trainees, or rather district judge and downwards, in a different way. This time, I like to say, I like to modulate my presentation to suit the requirement of lawyers, both prosecutors and defense lawyers. So, insofar as appeals are concerned, if you go to the provisions in the CRPC, you will find it in Chapter 29, starting from Section 372 to Section 394, subject to correction. Section 394, yes. 372 to 394 in the CRPC are the provisions relating to criminal appeals. But before going into these aspects, let me tell you some fundamental principles regarding any appeal for that matter. It is applicable to both civil and criminal appeals. Now, generally, every litigation should end. This is a very general statement, subject to a lot of exceptions, I know, but then I generally say that every litigation should end in the first court. That should be the reason. Otherwise, this will go on like that. But since the lawmakers or the legal system itself is aware of the fact that there can be mistakes in the trial court, so there must be another forum for rectification of the mistakes. That is why the appeals, revisions, and other things are provided for. So, as in any case, after trial, the aggrieved party should get an opportunity to complain before a higher court or a higher authority. In the case of tribunals, it can be even High Court in the original public remedy jurisdiction, whatever it is. So there must be a forum to make a complaint to the higher court that, look here, the trial court has committed a mistake. That is how the appeals are working. And as I told you earlier, every appeal, whether it be a civil appeal or a criminal appeal, is creation of a statute. You can't have a vested right. You can't have a fundamental right. You can't have a natural right or any other right thinkable in terms of our legal principles. It is actually a statutory right. If the relevant statute or the statute concerned provides a remedy by way of an appeal, then only you can file an appeal. In the context of Code of Civil Procedure 1908, shortly we call it CPC. In the context of CPC, it has been settled by earliest pronouncement by the Privy Council in 1923, where it is stated that appeal is the creation of a statute. It is not a vested right in any party. Likewise, none of the provisions of the Constitution would enable a party to file an appeal against a trial court judgment, whether it be civil or criminal. So the first principle to be borne in mind is that the appellate process is one by virtue of which a person approaches a superior court and invokes its aid to redress the error committed by the court below while adjudicating the case. That is what this Stroud's Judicial Dictionary says regarding appeals. Then as I pointed out, appeal is a statutory remedy, and the very wording in section 372 of the CRPC will make it clear. It says, the substantive part of the section says, because the proviso was added in the year 2009 by Act 5 of 2009, amended in by Act 5 of 2009. Before that, section 372 was having only one portion which says, no appeal shall lie from any judgment or order of a criminal court except as provided for by this code or any other law for the time being enforced. So it makes very clear. Section 96 of the CPC also almost similar wording there. An appeal is a creation of a statute. If only the statutory remedy is provided in the procedural law, you can file an appeal. That is the fundamental principle. Then the development of law, if you consider the amendment made by Act 5 of 2009 with effect from 31/12/2009, a proviso has been added to section 372, which says, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. So the proviso clearly says that a victim has a right. Victim, as you are aware, has been defined in section 2, section 2WA, subject to correction. Yes. Section 2WA, correct. Section 2WA in the CRPC defines victim. Victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. So this is the definition of victim. So in 372 proviso, a power has been given, or rather an authority has been conferred on the victim to file an appeal, dehodes the provisions in the substantive part of section 372 by saying that the victim, provided that whatever that is said in the first part of the section, the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused. So what are the grounds on which a victim can prefer an appeal? If the court acquits an accused, victim can prefer an appeal. Or convicting for a lesser offense. If he is convicted, charged with a major offense and convicted for a lesser offense, then also the victim will get a right. For example, one simple example, suppose he is charged with 376, rape, and convicted for 354, outraging the modesty of a woman, then probably the victim can file an appeal. So one is acquitting the accused, or convicting for a lesser offense, or imposing inadequate compensation. Mind you, the word is inadequate compensation, which can be imposed under section 357 CRPC, not inadequate fine. That is not the word used. So inadequate fine, there is no appeal. Acquittal, conviction for a lesser offense, and inadequate compensation are the grounds on which a victim can prefer an appeal. And this provision has been introduced by way of an amendment in the year 2009. So this is the history. This is the basic principle regarding the appeals. So we have seen that appeals are statutory remedies. If only the statute provides you can file an appeal, there is no vested right, there is no inherent right, there is no constitutional right, nothing can be done. It applies to both civil and criminal matters. Then there are certain cases which are exempt from appeals. For example, section 375. Now we will go to the appealable judgments later. Before that, section 375 CRPC says that no appeal in certain cases when the accused pleads guilty. When the accused pleads guilty, admits that he has committed the crime, and then he suffers a sentence, there cannot be an appeal because there is no adjudication regarding the guilt of the accused. He himself comes forward and pleads guilty, so that he cannot have a right of appeal. He surrenders his right of appeal. That is the principle in 375. I shall just read that provision to amplify another point. 375 says, notwithstanding anything contained in section 374, which deals with appeals from convictions. 374 is the substantive provision regarding appeals from convictions. Whatever that is said in 374, section 375 says, notwithstanding anything contained in section 374, where an accused person has pleaded guilty and has been convicted on such plea, there shall be no appeal. If the conviction is by a high court or if the conviction is by a court of session, metropolitan magistrate or magistrate of the first class or second class, except as to the extent or legality of the sentence. So in the case of a conviction by high court, there cannot be an appeal against the plea of guilt. It can't be. But in the case of a conviction by court of session, metropolitan magistrate of the first or second class, except as to the extent or legality of the sentence, there can be an appeal. Then what do you mean by except as to the extent and legality of sentence? What is the meaning of those expressions? Extent or legality of the sentence. I shall just illustrate that. Now, suppose a person pleads guilty for an offense, punishable with an imprisonment for 6 months, any offense for that matter. Let us not worry about the nature of offense. An offense which prescribes a punishment of 6 months, simple imprisonment. For example, simple imprisonment for 6 months. Suppose the court before which the person pleads guilty convicts him for the offense and imposes a sentence of 1 year, rigorous imprisonment, 1 year. Then he has a right to prefer an appeal, whatever stated in 375, whatever be the interdiction in 375, he gets a right to appeal because there is a, the extent of the sentence is not prescribed by the statute. Suppose he is only liable to undergo sentence for 6 months, the trial court mistakenly convicts him for 1 year imprisonment, he gets a right to prefer an appeal because the extent of punishment is not legal. So that is one situation. Then extent or legality of the sentence. Suppose the cumulative effect of the allegations against the accused in a different situation. I'm telling you a different situation. If the cumulative effect of entire allegations put together do not make out an offense at all, there are certain accusations, but that is not covered by the provisions of law with which he is charged. Or suppose he is alleged to have committed theft. You are aware, in the case of theft, moving of movable property from the possession of another person is the gist of the offense. It is an offense against movable property, and you must have unauthorizedly moved movable property belonging to another. So that is the gist of the offense. Suppose the allegations, when taken together, show that this was the accused came into possession of this article by way of some consent or some authority of law, then he can't be charged for an offense of theft. So by mistake, assume in a case the entirety of the allegations do not constitute an offense, but the accused, unaware of all these aspects, simply pleads guilty and the court convicts him for the offense of theft. Let us take the offense of theft as an example. Suppose he is convicted for an offense of theft, even without looking into whether the ingredients of all the allegations, whether it will make out an offense of theft, then it is legality of conviction. Because the conviction itself is illegal. All the entire allegations are only a story, and that will not make an offense. So such a conviction is also can also be challenged. That is the gist of section 375. So general principle in 375 is that you can't complain against a conviction if the conviction is based on a plea of guilty. But there are two exceptions. In the case of High Court, you have no option. But in the case of Court of Session or other courts of inferior jurisdiction, if the extent of sentence is illegal, the sentence which is higher than the prescribed sentence has been awarded, or legality of the sentence. Suppose the conviction and sentence is imposed based on allegations which do not constitute an offense at all, then you can file an appeal, whatever that is mentioned in section 375. So two exceptions to section 375. Then 376 also says, that is also actually an exception to 374. In petty cases, there are no appeals provided. Notwithstanding anything contained in section 374, there shall be no appeal by a convicted person in any of the following cases, namely, and then the situations are enumerated there, A to D and provisos also there. Please look into that. I'm not reading and explaining it because it's not worth wasting time on that. So section 376 deals with petty cases where no appeal, where the right of appeal has been curtailed, and 375 deals with conviction based on plea of guilty. There are only two exceptions for filing an appeal. So the general principle is that appeal should be filed only if it is authorized by law. Second thing, if there is a plea of guilty, there is no right of appeal. And for trivial offenses like petty cases and other small offenses, there cannot be waste of judicial time by hearing an appeal. And that is why section 376 is enacted. Now, these aspects. Now coming to appeal from convictions, because the scheme of the code, it goes like this. Section 374, cr.p.c, the scheme is like this. 374 deals with appeals from convictions, and 377 deals with appeal by the state government against sentence. That is different from 378, because 378 says appeal in case of acquittal. So in the case of 377 appeals, the state has only the state has the power to file an appeal. But in 378, if the trial was based on a private complaint, prosecution on a private complaint, even the complainant has a right under 378. Also, the state also have a right, no doubt. So there are three categories of appeals provided. One from convictions. So normally accused will prefer an appeal under section 374, complaining that the conviction is illegal and sentence is also illegal. Both ways he can contend. 374. And coming to 377, the state government can say that the sentence is either inadequate or not the one provided by the law. So many complaints the state government can raise. We will go to that section later. And 378 deals with the appeal against acquittal. So these are the three types of appeals mainly envisaged under the Criminal Procedure Code. So now we'll see 374. (374) says, any person convicted on a trial held by a high court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. I think none of the high courts are now exercising extraordinary original jurisdiction because it was exercised at one point of time. Now actually all the sessions courts are exercising the trial jurisdiction for the gravest offense, even for the gravest offense. Then, so that is subsection 1. If the trial is by the High Court, then the appeal is to the Supreme Court. Then subsection 2 says, any person convicted on a trial held by a sessions judge or an additional sessions judge, or on a trial held by any other court in which sentence of imprisonment for more than 7 years has been passed against him or against any other person convicted at the same trial may appeal to the High Court. So suppose there are two accused persons. One person, both were tried for the some same set of in the same transaction. Both these accused persons were arraigned and they are charged together and tried together. Suppose one is sentenced for life and the other is 5 years. Then the High Court will be to High Court for the appeal will be to High Court for the reason that even the person who suffered sentence of 5 years can prefer an appeal because the other person has been convicted for life. That is the scope. The person who has been convicted for life certainly can file an appeal before the High Court because 7 years or more is the interdiction in subsection 2 of section 374. Even the other person who has not been convicted for more than 7 years can also file an appeal before the High Court for the reason that one of the accused in the same trial has been convicted for an offense, imposed a sentence of more than 7 years. Then subsection 3 is regarding the trial held by a metropolitan magistrate or assistant sessions judge or a magistrate the first class or the second class or sentence under section 325 or in respect of whom order has been sentence has been passed under 360 by any magistrate may appeal to the Court of Session. So subsection 3 enumerates 3 contingencies where a convicted person can prefer an appeal to the Court of Session. So subsection 2 deals with the appeal to the High Court, 3 deals with the appeal to the Court of Session. Then subsection 4 is regarding the prosecution in the this newly added section to newly added provisions to section 376 IPC, which says that an appeal shall be disposed of within a period of 6 months, because these are all aggravated forms of sexual offenses, where the time limit is prescribed for disposal of appeal 6 months. So the sum total of section 374 is that if the trial is before the High Court, an appeal can be preferred to the Supreme Court. But nowadays, to my knowledge, there is no trial happening in any of the High Courts in this country. Then subsection 2 says, if a person is tried and convicted and sentenced for an offense and the punishment imposed is more than 7 years, he gets a right to prefer an appeal to the High Court. And any person who has been tried along with such a person, though not sentenced for more than 7 years, can also prefer an appeal to the High Court, because the trial is one trial. There cannot be two appeals. One appeal to High Court and one appeal to the Sessions Court is not possible. So the legislature has contemplated that situation also. Then coming to 3, it is there are 3 aspects which enable a convicted person to prefer an appeal to the Court of Session. So this is the sum and substance of section 374. Then once an appeal is filed, now let us consider the appeal from conviction. Once an appeal is filed, it becomes the bounden duty of the appellate court to consider the entire evidence adduced before the trial court and to marshal the oral evidence, to consider the documentary evidence, because the fundamental principle regarding appeal is that appellate jurisdiction is co-extensive and co-terminus to that of the trial court. That is, it starts from the trial court's jurisdiction and ends with the trial court's jurisdiction. So it is same. If you go to section 107 CPC, you will subsection 2, you will find the same principle stated. So power of appellate court is akin to that of trial court. So the appellate judge has every right to go through the entire evidence. I would put it in the other way. It is not every right. It is his duty to scan the entire evidence and find out what is the mistake committed by the trial judge in entering a conviction or imposing a sentence, if any, of course. So the power of appellate judge is co-terminus, co-extensive and co-terminus to that of the trial court. Appellate court should objectively and satisfactorily scrutinize and examine the evidence. The appellate court should not endorse the conviction and sentence passed by the trial court after mere narration of the prosecution case and brief references to the testimony of the prosecution witnesses. So it becomes the bounden duty of the appellate court to consider the entire matter afresh. If anybody wants a decision, please refer A 2002 Supreme Court 1814. A 2002 Supreme Court 1814. So then the powers of appellate court, you can find it in section 386, that we shall come later. Powers of the appellate court is specifically dealt with in 386, because 386 powers can be invoked in appeal against conviction under 374, appeal by the state government against inadequate sentence under 377, and appeal against acquittal under 378. In both the three, on all these 3 contingencies, the power wielded by the appellate court can be used as provided in section 386 cr.p.c, that we shall see later. Now coming to section 377 appeal, that is appeal regarding inadequacy of sentence. That power is solely vested with the state government. No party can file an appeal under 377. Save as otherwise provided in subsection 2, the state government may, in any case of conviction on a trial held by a court other than the High Court, direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy. A, to the Court of Session if the sentence is passed by the magistrate, and to the High Court if the sentence is passed by any other court. So in the case of magisterial trial, the appeal shall be preferred against inadequacy of sentence to the Court of Session. And in any other court, if the trial is before the Assistant Sessions Court or Sessions Court, then the appeal shall be preferred by the government under section 377 to the High Court. Then in the case of Delhi Special Police Establishment, that is CBI case, then also it depends, depending on the jurisdiction, it will go to the High Court or the Sessions Court, that is the provision in subsection 2, akin to the other provision, because it is only specially dealing with the CBI offences. Then subsection 4 deals with this amendment to IPC 376. That also stipulates that such appeal shall be disposed within a period of 6 months. So this is 377. I'm rushing through these provisions because I have to cover other aspects. So I think I'm very clear on this. 377 deals with a power of state government to complain against inadequacy of sentence only, even if there is a conviction entered by the trial court. If the state government or the prosecuting agency convinces the appellate court that, no, look here, the conviction is correct, but the sentence is not as prescribed by law. It is a flea bite sentence or a mockery of sentencing. Then they can prefer an appeal under section 377. Then another important aspect is 378. There the appeal, if appeal can be preferred under 378, either by the government or a private party at whose instance a complaint was preferred and trial happened by virtue of that complaint. So 378, the accused does not prefer an appeal because he will be happy by the acquittal. So he need not prefer an appeal. 378 right is enjoyed by the aggrieved party, a party aggrieved by the acquittal of the accused. So we'll just go through that 378. Save as otherwise provided in subsection 2 and subject to the provisions of subsections 3 and 5. The district magistrate may, in any case, direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence. So an accused involved in a cognizable and non-bailable offence, if he has been tried by a magistrate, then the district magistrate, who is the collector, can direct the public prosecutor to prefer an appeal against acquittal to the court of session. So that provision is very clear. There is no room for any doubt. Then B, the state government may, in any case, direct the public prosecutor to present an appeal to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being under clause A, or an order of acquittal passed by the Court of Session in revision. So, if the trial is before any court other than a High Court, it includes Sessions Court, Assistant Sessions Court, or this CJM Court, if law permits. Suppose the sentence is below 7 years, it can be. So, if the trial is before an Sessions Court and Assistant Sessions Court, and if the state government feels that the acquittal is an unmerited acquittal, the government can direct the public prosecutor to prefer an appeal to the High Court against the original or appellate order of acquittal passed by any court other than a High Court, and also against an order of acquittal passed by the Court of Session in revision. Suppose the revisional court, the Sessions Court, exercises its power and grants an acquittal, that also can be challenged under subsection section 378 1B. Then 2. If such an order of acquittal is passed in any case that is regarding CBI, same principle, CBI matters. I'm not elaborating that because same principle applies. Then, subsection 3. No appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court. So, what is required in the case of acquittal is that the appellant should get the leave of the High Court first. Then see, you can't, as a matter of right, barge into High Court with an appeal complaining that the acquittal is illegal. The reason is very obvious. Reason is that when there is a what you call presumption of correctness attached to the trial judgment, because the trial judge who had the opportunity to see the demeanor of the witness, record the evidence, who had the what you call the opportunity to go through the entire evidence, the initial presumption is that the trial judgment is correct in all respects. So, unless the person aggrieved by an acquittal under section 378 can prefer an appeal, unless the person who is aggrieved by the acquittal convinces the High Court that he is entitled to file an appeal under section 378, and if he obtains leave under section 378(3), then only he can prefer an appeal. So leave is mandatory. Then 4. If such an order of acquittal is passed in any case, and before that I'll just tell you one thing. There is a presumption that the trial judgment is correct. So the High Court should be apprised of the fact that the trial judgment is incorrect for such and such reason, 1, 2, 3, 4, whatever it is, either factual or legal. So then only you will get leave. And see, in our system of criminal trial, there is always a presumption of innocence, and the accused has a golden rule of golden right of remaining in keeping silence. So the accused right to keep silence and the initial presumption that every accused is innocent, and it is for the prosecution to establish that he has committed the offense. So that presumption of innocence gets fortified, rather reinforced by the acquittal, because one court considers his plea of innocence and finds that the accused has not committed the offense, which will be an additional benefit to the accused to say that, look here, I am innocent. Even in the trial court, I have said that I was innocent. And the trial court, after considering all the evidence in the case against me, produced by the prosecution against me, court is of opinion that I am innocent, and I am liable to be acquitted. Then if that gives an additional benefit to the accused to show that he is innocent. So that is why there is an insistence on the leave under subsection 3. Then subsection 4 says, if such an order of acquittal is passed in any case instituted upon a complaint, and the High Court, on the application made to it by the complainant in this behalf, grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. So subsection 3 deals with the government's request to seek leave, government's power to seek leave, or may authority to request the High Court for leave under subsection 3. Subsection 4 is the right conferred on a complainant who says that the acquittal of the accused who has been brought to the court on his complaint is bad. Then subsection 5 says, no application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, where the complaint is by a public servant, and 60 days in the other case computed from the date of the order of acquittal. So if suppose a police charge case or a PFI case, that is food adulteration, now this Food Safety Act. So a public authority or police officer moves a matter because a criminal prosecution is initiated at the instance of the state. Then the grant should be sought within 6 months. And if a private complainant, if a private party prefers a complaint and it ends in acquittal, then he should obtain the leave within 60 days. If in any case the application is accepted, grant of shall be if in any case the application of subsection 4 for the grant of special leave acquittal is refused, no appeal, etc. So no further appeal against refusal. So this is the time limit prescribed. Of course, the appellate court can invoke section 5 of the Limitation Act. That's a different issue, but the court prescribes a limit. So I should just sum up section 378. Section 378 visualizes two situations. One set of appeal by the government against acquittal, and the other set of appeals by the private complainant aggrieved of the acquittal. And in both cases, they should obtain leave. But in the case of a public authority moving for a leave, he gets 6 months and the other party gets only 60 days. And the High Court will consider whether the appellant has a right to file an appeal, because is there any gross injustice or rather violation of law or wrong appreciation of evidence. These are the reasons for entertaining an appeal. So if the High Court is satisfied that the acquittal is bad in law prima facie, then leave will be granted and the appeal will be heard and decided by the High Court. Then, so these are the provisions. One is appeal against conviction 374, appeal against inadequacy of sentence 377, and appeal against acquittal 378. Then 379 we are not concerned, because when the High Court reverses the order of acquittal and passes a sentence of imprisonment for life or death, then he can move the Supreme Court in appeal. That is what 379 says. It rarely happens in this. Probably that may not be relevant for our purpose here in this discussion. Then section 381 says, subject to the provisions of subsection 2, an appeal to the Court of Session or Sessions Judge shall be heard by the Session Judge or by the Additional Sessions Judge, provided that an appeal against a conviction on a trial held by a magistrate of the second class may be heard and disposed by an assistant sessions judge or a chief judicial magistrate. So normally an appeal not provided in this proviso will be heard by a sessions judge or an additional sessions. An additional sessions judge, assistant sessions judge, or a chief judicial magistrate shall hear only such appeals as a sessions judge of the division may, by general or special order, make over to him as the High Court by special or order direct him to hear. So the power to hear an appeal by an additional sessions judge or an assistant sessions judge or a chief judicial magistrate arises only when that matter is made over, transferred, or I don't use the expression transferred. Transferred is understood in different connotation. So it is made over for hearing and disposal by the sessions judge. So the power vests with the principal judge, principal session judge, as to decide as to who should hear this appeal. If he decides that it should be heard by an additional session judge, that will be made over to him. So power to make over is with the sessions judge. Then 382, petition of appeal. Then procedure 382 is petition of every appeal shall be in the form of a petition in writing, because the form is prescribed there. It shall be in the form of a petition in writing by appellant or his pleader. Then 383 is jail appeals. If the appellant is in jail, he may present his petition of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellate court. So when he is in custody or he is undergoing sentence, the accused appellant can hand over the petition to the jailer, and it is his duty to submit it before the court of appeal. In that event, the court will send notice to him, to the appellant as well as the government pleader or public prosecutor, and they will have to enter appearance, and the accused will be heard either through a counsel engaged by him. If he is not able to engage a counsel, if he is not having the wherewithal, monetary capacity, then court will engage a state brief or a legal aid brief, whatever, counsel, and the appeal will be heard, and the same power or the same responsibility lies in the court to hear and dispose of the appeal as in any other private party's appeal, because it becomes all the more it becomes the responsibility all the more on the court, for the reason that a poor person is appealing under 383. So the court should be very careful in dealing with the jail appeals. Then summary dismissal of appeal not required, because if upon it is seldom exercised. 384 summary dismissal of appeal is not generally done, and it is very rarely done. It is not advisable to dismiss an appeal in a summary manner. So I'm just keeping that. Then so now I'll go to 386, which is a crucial provision, which is very relevant for our discussion. 386 deals with powers of the appellate court. So appellate court, I told you at the outset that appellate court has all the powers of a trial court, and the power of the trial court and appellate court are coextensive and coterminous. Starts from the same point, ends at the same point. The provision in 386 says, after perusing such record and hearing the appellant or his pleader, if he appears, and the public prosecutor if he appears, and in case of appeal under 377 or 378, the accused if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal. So the appellate court's first power is to dismiss the appeal and confirm the sentence or conviction sentence, both. So that power is there. If it is satisfied that there is no reason made out to take a different view in the matter, but it should be done only after considering the entire evidence and the legal propositions urged before it. Then, or either it can dismiss the appeal, or in an appeal from an order of acquittal, reverse such order and direct that any further inquiry be made, or that the accused be retried or committed for trial as the case may be, or find him guilty and pass sentence on him according to law. In addition to the power to confirm the conviction sentence, the appellate court has a power in an appeal from an order of acquittal, that is an appeal under 378, reverse such order and direct that further inquiry be made. Either it can reverse the order and remand the case to the trial court for retrial, or suppose the trial is before a magistrate and the appellate court finds that it should have been tried by a court of session, then it can send back to the court with a direction to commit the case to the court of session under section 193 cr.p.c for trial as the case may be, or find him guilty and pass sentence on him according to law. Or the appellate court can consider the entire matter before it itself, before the court by the appellate court itself, and enter a conviction and sentence according to law. So there are three powers. One, reverse the order and direct that the matter be retried, or reverse the order and direct that the matter be committed, or reverse the order and find him guilty and pass sentence in accordance with law. So this is the powers envisaged under section 386A. Then B, subsection B. In an appeal from a conviction, the appellate court can reverse the finding and sentence, and acquit or discharge the accused, or order him to be retried by a court of competent jurisdiction subordinate to such appellate court or committed for trial. So in a case of appeal from conviction under 374, the appellate court can reverse the finding and sentence and acquit or discharge the accused. Either he can be acquitted or discharged, or order him to be retried. Or the appellate court can set aside the judgment of the trial court and remand it for retrial, either to the trial court or a court of competent jurisdiction. Or it can be directed to be committed for trial again. So these are the matters which can be done in respect of appeal from conviction. Then another power vested with the appellate court in the matter of appeal from conviction is that alter the finding, maintaining the sentence. So the sentence can be maintained, but the findings can be altered, can be varied. Right? Then, with or without altering the finding, alter the nature and extent of the sentence, but not so as to enhance the same. So, with or without altering the finding, the appellate court can alter the nature or the extent. Suppose it is rigorous imprisonment for 6 months. It can be made simple imprisonment for 6 months. Or suppose rigorous imprisonment for 6 months is awarded by the trial court, the appellate court can modify it, alter it to rigorous imprisonment for 3 months or simple imprisonment for 3 months. But it can't be enhanced because this is an appeal by the accused person. So against his interest, unless there is an appeal under 377 by the state, the appellate court cannot enhance the sentence in an appeal preferred by an accused who has been convicted by the trial. Because he can't be, suppose the state has not preferred an appeal, then in an appeal preferred by the accused, his sentence cannot be enhanced. That is the principle there. Then C deals with the situation under 377. In an appeal for enhancement of sentence, the appellate court can reverse the finding and sentence and acquit or discharge the accused or order him to be retried by court of competent by a court competent to try the offense. Same power as in the other cases. Alter the finding, maintaining the sentence, or without altering the finding, alter the nature or the extent or the nature and extent of the sentence so as to enhance or reduce the same. In the case of a enhancement of sentence, the appellate court can enhance a sentence because it is aggrieved by the inadequacy of the sentence. The state has come in appeal. So essentially, this has to be decided only after hearing the accused. So there is no prejudice caused to him. That is why in clause C to section 386, the High Court or the Appellate Court has given power to enhance the sentence after hearing the accused or the convict, because the state's grievance is against inadequacy of sentence. But this can't be done in an appeal preferred by a convicted person under 386B, because the state has not preferred an appeal. So his sentence cannot be enhanced in an appeal preferred by him against conviction. So that is the difference there. Then D, it's a residuary provision. In an appeal from any other order, alter or reverse such order, make any amendment or in consequential or incidental order, etc., provide that the sentence shall not be enhanced unless the accused has been had an opportunity of showing cause against such enhancement. Because suppose 377 appeal or 378 appeal is there, the accused should be given an opportunity to challenge the prosecution's case for enhanced punishment or conviction. So that is section 386. 386 deals with three situations. One, appeal from appellate court has all the powers of a trial court. it can confirm the conviction and sentence and dismiss the appeal, or it can, in the case of, it can acquit or reverse or order retrial or remand the case for retrial or direct the trial court to commit the case for trial. So all such powers are very extensive powers are there under 386. And from a conviction, appeal from a conviction, the appellate court can confirm it. It can alter it or modify the sentence, alter the conviction, modify the sentence, but enhancement shall not be done against the interest of the accused who preferred the appeal against conviction. But in the case of appeal for enhancement of sentence preferred by the state under 377, the High Court or the Appellate Court has all the powers as mentioned above, and it has the power to even to enhance the sentence after hearing the accused. So the principle is that the natural justice theory must be satisfied. The accused should be given an opportunity when the appellate court proposes to enhance the sentence. So that is the gist of section 386. Now, another important provision which is worthy to be mentioned here is 389. 389 is the power of the appellate court to suspend the sentence pending the appeal. Because once an appeal is preferred, the theory is that every appeal, if entertained, the theory is that the judgment of the trial court is put in jeopardy because it is actually in a suspended animation, can't be executed. Otherwise, there will be no point in hearing the appeal. Suppose the accused undergoes imprisonment despite filing an appeal, then of course that will be against the spirit of appellate power. So the courts have been given certain authority to suspend the sentence passed by the trial court. Either the trial court itself can suspend the sentence up to a certain limit, or the appellate court can suspend the sentence. But normally, I can tell you one thing, normal principle is that when the sentence imposed in a trial before a court of session is imprisonment for life or death, normally none of the courts suspend the sentence very lightly. But if it is 10 years or below, normally the High Court liberally used to suspend the sentence on certain conditions, not unconditionally, but it is very common to give suspension. But in the case of life imprisonment, the appellant cannot as a matter of right, or in the case of death sentence, the appellant cannot as a matter of right claim suspension under 389 cr.p.c. Let us see what the section says. 389(1) says, pending any appeal by a convicted person, the appellate court may, because it is the discretion of the court, it is not shall. Appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence or order appealed against be suspended, and also if he is in confinement, that he shall be released on bail or on his own bond. If he is in custody undergoing the imprisonment, then he shall be released on bail after suspending the operation of this sentence, provided that the appellate court shall, before releasing on bail or on his own bond, a convicted person who is convicted of an offense punishable with death or imprisonment for life or imprisonment for a term not less than 10 years, shall give an opportunity to the public prosecutor for showing cause in writing against such release. So in the case of a person, appellant, who has been convicted for death, imprisonment for life, or any imprisonment above 10 years, the prosecutor should be given an opportunity to oppose his plea, and after hearing only, the suspension can be granted. That's what I say. Normally, they will stiffly oppose it. The prosecution, the prosecutors, either before the court of session or the High Court, will strongly oppose suspension of such serious offences, and the court then will have to consider whether there is a prima facie material to show that the appellant is entitled to get a suspension under 389. It is very difficult in most cases. Then subsection 3 says, where the convicted person satisfies the court by which he is convicted that he intends to present an appeal, the court shall, where such person being on bail is sentenced to imprisonment for a term exceeding 3 years, not exceeding 3 years, or where the offense of which such person has been convicted is a bailable one, he shall be, and he is on bail, or that the convicted person be released on bail. So which says, subsection 3 says, the trial court itself in certain situations, can suspend the sentence and grant bail to the accused on certain conditions. Let us see what is that. The conviction is for not more than 3 years. So sorry, the sentence is not for more than 3 years. Suppose let us take 326. Triable by a magistrate. 326 APC is triable by a magistrate. Grievous hurt. And the sentence prescribed is actually 10 years, but trial being magistrate, even CJM can only give 7 years imprisonment. Suppose the sentence, the conviction is grievous 326, but the sentence is only 3 years. Then the same court can suspend it under 389(3). But if it is beyond 3 years, even a trial before an assistant sessions judge or a sessions judge, if the sentence imposed is beyond 3 years, it cannot exercise the power of suspension under subsection 3. That is one condition. Second condition is that he should be on bail. The accused should have been on bail. Then only the power under 389(3) can be suspended. Invoked for suspension. Being on bail is sentenced to imprisonment for a term not exceeding 3 years. So the person must not have been sentenced for more than 3 years, and he should have been on bail during trial. So when these two conditions are satisfied, the power under 389(3) can be invoked by the trial court for suspending the sentence, for enabling the accused to prefer an appeal. Then another situation where the offense of which the person has been convicted is a bailable one and is on bail. If the offense is bailable one and the accused is on bail, then also it can be suspended by the trial court. So 389(1) deals with the power of the appellate court to suspend the sentence, and 389(3) deals with the power of the trial court itself to suspend the sentence. Then another power available in the appellate jurisdiction is to produce additional evidence. You are aware that normally I told you that the power of appellate court generally, whether it be a civil appeal or a criminal appeal, the general power of the appellate court is start from the same point and ends with the same point as that of the trial court. But in certain situations, as in the case of Order 41 Rule 27 in CPC, you will find the power of the appellate court to take additional evidence. But it is not a general rule. General rule is that the appellate court shall decide the matters with the available evidence. Additional evidence is only an exception, very rare exception. So, akin to Order 41 Rule 27 in the CPC, we find 391 here in cr.p.c, which says the appellate court may take further evidence or direct to be taken. In dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, because it is a satisfaction of the court, it is not a right for a party to adduce additional evidence in an appellate court. No, he can't do that. If the court feels that additional evidence is required in a case to do complete justice in the case, then it can direct that the evidence be adduced, shall record its reasons. So it should record its reasons also. For such and such reason, I am of the view that additional evidence is required for doing complete justice in this case. So see, you can simply say that, yes, this is a case where I feel additional evidence is required. No, you should state the reason for that. Evidence or direct it to be taken by a magistrate when the appellate court is a high court or a court of session or a magistrate. So suppose the appeal is being heard by a high court or the court of session, both courts can direct the magistrate concerned to record evidence and send it to the high court or the sessions court, as the case may be, for consideration. So either appellate court itself can take evidence, permit the evidence to be adduced, or it can direct an inferior court, a magistrate, to record evidence and send it to the higher court. Then subsection 2 says, when the additional evidence is taken by the court of session or the magistrate, or it shall certify such evidence of the appellate court, and such court shall thereupon proceed to dispose of the appeal. So there must be a certification by the court recording evidence that this is truly and correctly recorded. Then it will be sent to the appellate court, and the appellate court will consider this evidence along with the other evidence available in the record. So this is an exception to the general rule that the appeal shall be decided with the available evidence. That is the general rule. There may be exceptional situations in some cases. That is why 391 power is given to the appellate court. And subsection 3 says the accused or his pleader shall have the right to be present when the additional evidence is taken, because it shall, every evidence shall be recorded. That is the fundamental principle of our criminal law, that it shall be recorded in the presence of evidence. Nothing can be done behind his back. So accused or his pleader has a right, to what you call, be present at the time of additional evidence. And it says that it will be an inquiry deemed under Chapter 23 of the cr.p.c, which deals with the inquiry and other aspects. Then 392, I am not touching, that is not required for our purpose. Then finality of judgments and orders in appeal. Then 394 is abatement of appeals. Now you are aware, as in the case of civil actions, the death of the party causes abatement. But in 394 cr.p.c, there are certain exceptions where the appeals are not abated. Every appeal, I shall just read and then explain. 394 says every appeal under 377, that is appeal against inadequacy of sentence, 377, by the state government. Every appeal under section 377 or section 378, that is appeal against acquittal, shall finally abate on the death of the accused. So that is very clear. So when the state government's grievance is that the conviction is correct, but the sentence is inadequate under 377, or the acquittal itself is bad under 378, then what you call, even a private complaint under 378, appeal against acquittal on the basis of a private complaint. So any appeal under 377 or 378 will finally abate on the death of the accused, because after his death, there cannot be a trial, because appeal is virtually a continuation of trial. So it can't be done in his absence from this world. So that is the fundamental principle. So such appeals, 377 and 378 appeals, will be completely abated. Then subsection 2, every other appeal, that is every other appeal means actually 374 appeal or appeals provided by any other law. Every other appeal under this chapter, except an appeal from a sentence of fine, shall finally abate on the death of the appellant. So every other appeal under this, except appeal from a sentence of fine. Suppose the appeal is against appeal by the convict, where the imprisonment alone is prescribed, no fine is prescribed. Then of course he can that situation is provided by the proviso, provided that where the appeal is against a conviction and sentence of death or imprisonment, and the appellant dies during the pendency of the appeal, or any of his near relatives may, within 30 days of the death of the appellant, apply to the appellate court for leave to continue the appeal, and if the leave is granted, the appeal shall not abate. So this subsection 2 is controlled by proviso, which says in any appeal against a conviction and sentence of death or of imprisonment, and the appellant dies during the pendency of the appeal, any of his near relatives may, near relatives includes wife, husband, children, brother, sister, that is covered by decisions, within 30 days of the death of the appellant, may apply to the appellate court for leave or to continue the appeal, and if the leave is granted, the appeal shall not abate. So the subsection 2 is controlled by the proviso. Normal rule is that every appeal will abate unless the proviso remedy is sought by the near relative. But in the case of an appeal where sentence includes fine, it will not abate. Why? Because fine is a liability on the estate of the deceased person. Whatever that is left behind by the deceased, the estate, the assets left behind by the person will be liable for this payment of fine. Therefore, appeal where the composite sentence of conviction and fine, or fine alone, that will not abate, because it is a liability on the estate of the deceased. In other cases, if it is only against a conviction alone, and if the near relatives do not come forward within 30 days of the death of the appellant, then such appeals will abate. But if there is a component of fine as part of sentence, such appeal will not be abated. That is subsection 2. And there are decisions, 76 Supreme Court and many other decisions which say that even in the case of a composite sentence of imprisonment and fine, the appeal will not abate because it is predominantly an appeal imposing a fine also. So even though the code says except an appeal from a sentence of fine, the Supreme Court has interpreted by saying that composite sentence of imprisonment and fine will also remain intact and will not be abated under subsection 2. So this is the principle in 394. So we just had a bird's eye view of these provisions in this chapter relating starting from 372 to 394, the relevant aspects. And then certain decisions probably I can give you that will be of some use to you. In appeal against inadequacy of sentence, the Supreme Court in 78-4 SCC 196, that's a classic decision on the point, 78-4 SCC 196. It is held that according to section 377 of the Code of Criminal Procedure, the Sessions Court has powers to entertain appeals against inadequacy of sentence passed by the magistrate. While proceeding to entertain such appeals, the sentence may not be enhanced without giving the accused an opportunity to show cause why the sentence may not be enhanced, as the same is mandatory, not only in the light of the provisions of the Code of Criminal Procedure, but also according to the rules of natural justice. In the course of resisting enhancement of sentence, the accused can also plead for acquittal or for reduction of sentence. Further, while altering the sentence passed by the trial court, the appellate court must counter by clear ratiocination the reasons given by the trial court. The appellate court should not alter the sentence merely by using broad phrases like ends of justice. Then the case of appeal against acquittal, you may refer to the two decisions laying down the proposition that while entertaining appeals relating to cases where two views of evidence are possible, one view in favor of the acquittal should be preferred. That is a principle in 75-3 SCC 150, 1975-3 SCC 150, AR 2004 Supreme Court 124. AR 2004 Supreme Court 124. Then if the trial court has resorted to perverse application of principles of evidence or shows lack of appreciation of evidence, the appellate court may reappreciate the evidence and reach its own conclusion. That is in 79-1 SCC 355. So these are all broad principles touching upon, and one decision that is of some importance, you may please go through that decision, that is AR 1997 Supreme Court 3258, where the broad principles have been mentioned regarding the appellate power in the case of appeal against acquittal. 97 Supreme Court 3258. So additional evidence I mentioned 391. So these are the brief contour of the appellate powers. So appeal is a statutory remedy. It can be preferred only when it is provided. But in the year 2009, there was an amendment which gives an unbridled power to victim to prefer an appeal if it is against acquittal or acquittal or convicting for a lesser offense or imposing inadequate compensation, not fine. And 374 deals with appeals against acquittals. 377 deals with the state government's power to appeal against inadequate sentence. And 378 deals with the appeal in case of acquittal, both on police report and on private complaint. And in both situations, the leave of the court is to be obtained. High Court has to be obtained in the case if the appeal is preferred before the High Court, because there is a reinforced presumption of innocence in favor of the accused. Then 375 and 376 are the provisions where appeals are not entertained if it is based on the pleading guilty in 375. Two exceptions are there. One is extent and legality of the sentence. I explained what is extent and legality of the sentence. And 376 enumerates certain situations where no appeal in petty cases. Then procedure in jail that we have seen. Then 386, please go through the relevant decisions in 386, which will tell you the powers of appellate court, because the three situations in 374, 377, and 378 have been separately considered, or rather enumerated in 386. And the power of the appellate court, generally speaking, is to confirm the sentence, set aside the conviction sentence, to remand the case for retrial, to remand the case with a direction for committal, or alter the conviction and sentence, or alter conviction alone or sentence alone. So a lot of powers are wielded by the appellate court under section 386. Then 389 deals with the power of suspension. 389(1) deals with the power of suspension by the appellate court. But in the case of conviction, the sentence is death, imprisonment for life, or for any sentence which is more than 10 years, public prosecutor should be given an opportunity to oppose it. And in other cases, the court can consider this even in the absence of public prosecutor's opposition. And subsection 3 to section 389 deals with the power of the trial court to suspend sentence for enabling the accused to prefer an appeal. But there are certain situations, there are certain conditions. One such person is being on bail and sentenced to imprisonment for a term not exceeding 3 years. So he must be on bail and the sentence must not have been more than 3 years. Or where the offense is of such a person has been convicted is a bailable one and he is on bail. If he is convicted for a bailable offense and he is on bail, then also 389(3) can be invoked by the trial court. And 391 deals with the power of appellate court to adduce or gather additional evidence, which is against the normal rule that the appellate court shall decide the matters on the available evidence. There are situations I have mentioned. Then 394 is the abatement of appeal. Normally, every appeal under 377 and 378, that is appeal for enhancement of sentence and appeal against acquittal, both will abate on the death of accused or the convict. And in subsection 2, which says, except in the case of a fine, all other appeals will abate. But proviso says that when a near relative of the deceased convict comes forward within 30 days of the death of the appellant, they can continue. But in the case of fine or a composite sentence of imprisonment and fine, the appeal will not be abated. And I can tell you one more thing: the appellate courts have no power, no authority, or no right to dismiss an appeal for default. The appeals must be decided on merit. It can't, even in the absence of the appellant, whether it be the state or whether it be the convicted person, the appeal cannot be dismissed for default, as in the case of civil appeals. Every criminal appeal has to be decided on merit. It can't be just thrown out in the absence of the aggrieved person. So the lot of decisions are there. I need not labor on that, because it is a well-settled proposition of law that the appellate court is bound to write a judgment on merit in all cases, whether the party is present or not. If the court, suppose the party is absent, his pleader is absent, the court can appoint an amicus curiae or a state brief to help it. And after marshalling the evidence and considering the legal principles alone, the court can dispose of the appeal. No dismissal for default permissible. Same is the principle in the case of revision also. It can't be dismissed for default revision, criminal revisions. So this is the sum and substance of our topic. And if there is any question, probably I can take, because already it is 7:50. Because I think I'll stop it here right now.
Yes, sir.
Okay.
In fact, we have many questions.
Okay. I think within 15 minutes, whatever possible, we'll do that.
Yeah. In a case of appeal against conviction, whether suo motu revision can be exercised to convict the accused for the offense with which he got charged.
No. An offense for which he is not charged cannot be, he can't be tried for that. Then how can there be a revision for convicting him? An offense for which a person, see, what is the purpose of framing a charge? he should be made aware of the fact that, look here, the allegations against you will constitute a particular offense under a particular statute. And he is bound to answer that. If there is no charge and if there is no allegations, he can't be tried. If he can't be tried, how can there be a revision against him? The revision, purpose of revision is to correct, see, the revisional court's jurisdiction is to correct the legal, consider the legality, propriety and regularity of the proceedings. So if there is no illegality, there is no irregularity, there is no impropriety, the revision power cannot be exercised. So there cannot be a doubt on that. Yes.
Even otherwise, the thumb rule is like what we say, nobody can be condemned unheard.
Correct.
Even in the civil law.
Correct. Correct.
Even in the disciplinary proceedings, they say that if you're not being charged for something,
Absolutely,
you cannot be punished. You cannot go beyond the charge sheet.
No. So because suppose you go to this disciplinary proceedings or any civil action, if that is the principle, it is all the more rigid in the case of a criminal trial.
That's what I'm saying. On the basic thumb rule that
Yes.
beyond a reasonable doubt and preponderance of
Yes,
probabilities.
yes. No doubt.
And so what do you mean by cognate offense?
Cognizable offense.
No, cognate offense. Cognate.
Cognate offense means, suppose, for example, one is, there are two concepts. Cognate offense means of the same nature. See, almost the ingredients are akin. Cognate, say, you see, even in Hindu law, the expression cognate, agnate, cognate. Cognate means related through father. In Hindu law, I'm telling you about Hindu law principle. Agnate means through the mother. But in the case of cognate means almost the ingredients must be the same. I can tell you one example. For example, there are certain connection in 354. IPC 354 deals with the outraging the modesty. Suppose the private part of a lady is touched upon by a person. It is outraging the modesty. But in the case of a rape also, such an incident is included. Is it not so? But rape is an aggravated form of this. So when you do a particular act, if it is a lesser form, which in the rape also, this 354 ingredients are included. But since you are charged for a larger offense, the significance of this lesser offense pales, lesser offense pales into insignificance. So cognate offense means there are some similarity in the acts which constitute the offense.
If a person is convicted by a magistrate court and prefers an appeal to the Court of Session, which also maintains conviction, what remedy is available to an accused?
If once more, please, I did not get the question.
Magistrate convicted by session, then what is the remedy?
Remedy is to prefer a revision before the High Court. There cannot be a second appeal. There is no second appeal as in the case of a civil case in a criminal proceeding. If the first appellate court is a sessions court, then the revision to High Court under 397 cr. This is the only remedy. Or 482, if it is permitted. Yes.
Do you agree with the provisions, section 378, subclause 3, which provides High Court leave to appeal to the High Court, whether questions considered at the time of granting leave can't be considered at the time of appeal?
No, see, at the time of considering whether leave has to be granted or not, the only consideration is whether there is there is some prima facie case established by the appellate to show that there are glaring illegalities or irregularities in the trial procedure. See, that is why I started by saying every trial court is judgment of the trial court is presumed to be correct. It's only a presumption. It's a rebuttable presumption. We find thousands of examples where trial courts are going wrong. That's a different issue. But then the law can only presume that the trial procedure is correctly done and the decision is correctly arrived at. But when it is pointed out before the appellate court under 378 seeking leave, then the court will consider, yes, look here, there are certain irregularities. Anyway, we will admit the appeal. Because for doing complete justice, he should be given one more opportunity. You can't simply barge into the court. There is a screening. As in the case of SLP before Supreme Court, you can't simply go inside. That is the only scheme. 378 is not a very rigid, leave under 378 is not a very rigid rule. You have to establish that prima facie the trial judgment is incorrect. That's all.
What amendments do you suggest in the provision so that the pendency of the cases can be reduced?
That's not a matter for our concern. Let the machinery work on it.
Primarily, all questions are on this thing only. except one question we can take. Please throw light on the appellate power to entertain fresh evidence.
391 is the provision which says, no, that's why I started by saying that general rule in any appeal, whether it be a civil appeal or a criminal appeal or administrative appeal, whatever it is, the materials on record will be considered and a decision will be taken, because we are considering whether the original authority had gone wrong with the materials placed before it. So suppose you freely accept additional evidence in every appeal, you can't say that the original authority was wrong, because original authority must not have had the opportunity of seeing the additional evidence produced before the appellate court. If that is allowed, and you can't complain that the original authority was wrong, things were not produced before him, how can he be blamed for saying that no, he did not consider this? So the normal rule is that every evidence should be produced at the first court, at the trial court. That is a normal rule. But there are certain exceptions. I told you in the case of Order 41 Rule 27 CPC or in 391 cr.p.c, there are certain situations where if the court is satisfied that for valid reasons, the party could not produce the evidence before the trial court, and he could not establish that this evidence will be beneficial for him or this will tilt the balance in his favor. If there are exceptional situations only, 391 can be invoked. Suppose a person, for example, in a criminal trial, a vital witness was omitted to be summoned. It was a mistake. And it is established in appellate court that his evidence is very crucial. So please look here, he should be resummoned. Then the appellate court can direct the magistrate. Either it can take evidence by itself, or he can direct the magistrate, directing him to summon that witness and record his evidence in the presence of the accused and prosecution. And the evidence will be sent to the appellate court. So there are certain rare situations where 391 can be invoked, but it is not a general rule.
Thank you, sir, for sharing your insights.
Thank you.
Showed that we had what we call in the news channels, super fast, super 20. So it was just like that we did hurriedly the broader contours, and you have marshaled the facts coupled with law in a snippet of 1 hour, 20 minutes. So I feel that everybody would be enriched by that. And I've seen on the YouTube, that is also one of the fastest growing session.
Okay.
So thank you, everyone. Stay safe, stay blessed.
Tomorrow
we have session by Justice K.T. Sankaran on the amendments in the CPC at 9 p.m. since the courts are on. So do stay connected with us. Yes, sir, you were saying something.
Okay, no, I just wanted to tell you that this short sessions will create a sense of inquisity in the mind of the audience, or rather the participants, so that they will have an urge to read and go through the various nuances of the provisions that we discussed in the short time. Suppose it's a very long lecture, people will get bored and they will lose concentration. So everything in brief form will be more attractive for the listeners. That is my reading about.
That's true. One can always do that. Yeah.
All right, Mr. Vikas, thank you for the opportunity.
Yes, sir.